had that misdemeanor upgraded to a felony, I don't think they would. So that's advocate here, but I would say 34 counts are all on the same thing, right? So it sounded a lot worse than it was. It was all about the same falsifying of business records. I think the unfairness point really is, would any other businessman have had that misdemeanor upgraded to a felony? I don't think they would. So that's where it looks to me like a Democrat-motivated Alvin Bragg, who is a Democrat and was on record saying...
Here's the reality that exposes the dishonesty of Piers Morgan. And before I say anything else, keep in mind, this is what he does for a living. This is his bread and butter. This is his job, right? So he would necessarily have to be more motivated to look into these things. And you never expect him to be asking questions that are easily answerable if he's a good faith actor. So case in point, he's asking this hypothetical question. I don't think any other businessman would have been treated this way. I'm going to demonstrate that that is not a serious question. That's a dishonest, manipulative question, because he definitely did not do any investigating. So he's definitely not asking a real question. Well, he's not actually curious or, having a dialogue of like, I don't think anybody else would have. That's not a legitimate thought, right? Because if that was really what he thought, being that this is his job, he would have looked into it, and he would therefore know that this is actually normal behavior. The only thing that's abnormal is that Trump is not being treated more harshly than he is. Case in point, I spent less than a minute. I would say this is the result of a 30-second Google search. And I ran into this article. And a very important detail is the date on this article, right? So this is from July of 2013. This is long before Trump was even a thing, long before the current case. So this allows us to sidestep any of the partisanship and the propaganda and the right wing saying this and the left wing saying that, right? This is not a political website. This is not even mainstream media. This is a criminal lawyer blog, right? So this is a blog that is specifically dealing with matters of the law. And the title is A Review of First-Degree Falsifying Business Records, How Actions of a Third Party Can Still Violate the New York PL 175.10. And I'll get straight to the point. We're going to read some of this, but I'm going to get straight to the point. This guy was charged with the same crime that Trump was charged with, even though he didn't have anything to do with any documentation whatsoever. Right? However, per the way the law is written, he was found guilty. Think about that for a second. Piers Morgan wants to suggest that Trump was being treated unfairly. Yet here's a guy from over a decade ago found guilty of the same thing Trump was, even though this guy didn't do any documentation. You know who did documentation? A third party. A store put in false records in their record book unknowingly as a result of the crime that this individual committed. The store was not involved directly. They didn't intentionally violate any laws. And they're not the ones who were charged. He was charged. He was charged because his actions, his criminal actions, led to the creation of a false business record. Right? But again, he didn't create the record. It was the business that did it, but he was still found guilty. Let's examine. A review of first-degree falsifying business records, how actions of a third party can still violate this law. While felony arrests and investigations involving second-degree forgery and second-degree criminal possession of forged instrument are two of the more common fraud crimes in New York City and New York State, there are certainly many more crimes involving deceit and fraud that are prosecuted by assistant district attorneys and defended against by New York criminal lawyers. One of these crimes, falsifying business records in the first degree, 175.10, same thing Trump was found guilty of, may not be as serious as the felony forgery and forged instrument crimes. I'm going to repeat that again. May not be as serious as the felony forgery and forged instrument crimes. But an arrest for this felony in one that can land a first-time offender with no criminal history behind bars for an extended period of time. Again, this can lead to time behind bars for someone with no criminal history, just like Donald Trump. But I can almost guarantee you Trump is not going to serve a day in jail. I don't think he's even going to get house arrest. But let Piers Morgan tell it, let the right-wing media tell it, he's being treated harshly. And this is all to stop him from being president. He was found guilty. He violated the gag order multiple times. They could have put him in jail. They didn't. He was found guilty of something that this blog from 2013 says can find a first-time offender behind bars, yet that is very unlikely. But yet somehow this is an attempt to stop him from winning the presidency. How do you try to stop someone from being president? By convicting them of something where you could put them in jail, but then not putting them in jail. By allowing them to just disrespect the court multiple times. Think about this. This thing says someone without a criminal record could definitely find themselves in jail for this. So what do you think would happen then if a normal person attacks the court multiple times, attacks the jury, violates gag orders, and then after found guilty, going at it's a sham. What do you think would happen to a normal person? How can him being treated better than a normal person be an example of weaponization of the DOJ and a political trial that's only going after him because he's Trump? In fact, the punishment and sentence for this felony of first-degree falsifying business records is as much as 4 years in prison. So in here they want to talk about how indirect actions or secondary results can still be criminal. So generally a person is guilty of this when he or she has an intent to defraud that involves the commission or intent to commit another crime or the concealment of another crime. And when he or she makes or causes a false entry to be made, notice the language, he or she makes or causes. So that would be how someone who didn't make the entry and is not involved in the entry directly could be guilty of this. Because what happened was the person was basically, I think, returning items that they didn't purchase somehow. That's a scam I hear people are doing. So you didn't actually purchase the item, but you return it, and then you get the credit, and then you use the credit to buy something. By doing these things, this person was causing a false entry to appear on the books of the store. Because the store is going to log that this person bought something and returned it, but they didn't actually buy it, right? So I don't know if they were taking things off the shelf and then bagging it up and using somebody else's receipt or something like that, but they did not purchase this item. So it was not a valid return, right? The store doesn't know that, right? But the fact is it's a false entry. And who caused the false entry to be made? This guy, right? The guy who has nothing to do with the store. He's the one that caused the entry to be made. Therefore, according to the way the law is written, he's guilty of this crime. So, at its core and in non-legal terms, if you're trying to hide a theft or commit a larceny, and in the course of this crime, you intentionally make false entries in the records of a business, you would be guilty of felony falsifying business records. Not misdemeanor, felony. This is merely an example and would need further vetting to see if the crime was actually committed and each element satisfied. It says here, it is sufficient if one's actions cause a change to be made. The following legal decision helps to illustrate this point. In People versus Ramirez, this was 2012, an appellate court grappled. There wasn't too much grappling in actuality, as this court was clear and concise in its analysis. A defendant appealed from a conviction for falsifying business records in the first degree. The evidence at trial established that Ramirez knowingly returned merchandise to Lord & Taylor store in exchange for store credit. However, the defendant never purchased the merchandise he returned. Once he obtained the store credit, he then made purchases with the monies from the fraudulent return. Despite the defendant's contention that the prosecutors failed to establish a violation of falsifying business records in the first degree, the court stated that the people established that the defendant caused a false entry in the business records of an enterprise, that she returned merchandise that she had not in fact purchased, and that she thereby intended to aid or conceal her commission of the crime of petty larceny. Simply, this case did not hinge on whether the defendant made an actual false entry, as if he or she was an employee of the store, but that as a result of his initial fraudulent return of the merchandise, a change or entry was made in the records of the business reflecting the return or transaction. Even more simple, it is imperative to recognize that the action of the third party who makes these changes can be the basis of your criminal conduct, assuming all other elements of falsifying business records is satisfied. So, regardless of what you think about whether Trump should have been tried for this, or the judge is a Democrat, or Bragg is a Democrat, or you think that they're doing this to try and stop Trump, I'll give you all of those things. Let's say you're correct in all of those things. That still has nothing to do with the very fact that Trump being convicted of this is nothing strange. It's not a novel interpretation of the law. It's not something that is extra legal. It's not some fraudulent, bogus charges. It is simply an application that respects the law as written. Anyone who doesn't like that Trump got convicted for this should have problems with only two things. Trump for taking the actions that he did, which opened the door for this case in the first place. Had he accurately reported the spending that he did and not try to hide what he was doing, there would be no case. So, first and foremost, your issues should be with him for taking the actions which enabled whatever you believe is happening. If you think this is a partisan trial or whatever, they could want to stop Trump all they want to stop Trump, but they can't create a case out of thin air. They required Trump to take these actions for them to be able to take him to court for the actions that he took. The secondary thing that you can logically have an issue with is the law. If you don't like the law, you think this law is overly harsh, which is ironic because the idea is New York doesn't like to prosecute people and they're soft on crime. But if you believe that this soft on crime New York has a law that is too harsh, I mean, wow, false entry in a business record and because you did another crime, it's a felony? I mean, that's too extreme. Okay, if that's your opinion, that's fine. That's a legitimate response to have. That's a legitimate complaint. You think the law is too harsh. But don't pretend the law doesn't exist. And don't pretend like Trump, who is being treated with kid gloves, is being treated somehow uniquely harshly. And absolutely, the idea that no one has ever been convicted of this and no other business person would ever be convicted of this. Again, someone got convicted of it who didn't even make the entry. Right? They made no business entry. They made no false entry at all. And they were still convicted based on the language of the law. You don't like the language of the law? Complain about the law. Everyone that's upset in the right wing should be like, this law is stupid. This is a dumb law. But that's not good for content. It's more profitable to pretend like somehow this was a scam. Right.